Hello. Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the pleasure of bringing Jamie Moses, a Fisher Rushmer, a board-certified appellate attorney, to speak with you today about preservation of error. Jamie, welcome.
Thank you.
Thank you for coming back.
You're welcome.
First of all, what is preservation of error?
In order to get an appellate court to review something that has happened down below, you have to preserve the error. Our appellate courts are error-correcting courts. It's not a second opportunity to try to win again. You have to prove that an error happened. The only way you can do that is to preserve the error, and that's preservation of error.
So that's the importance of it?
Yes.
Or can you go further into the importance of the preservation?
Yes. Very few things an appellate court can fix that hasn't been preserved. Very few things. In fact, the exceptions to preservation of error are predominantly found in the criminal law. So as a civil practitioner, if you haven't preserved the error for the appellate court's review, then they don't look at it. So for example, if you have a problem with a juror that's been selected, there are certain things you have to do in jury selection and before they're sworn in that constitute preserving the error. If you don't do those things, then the appellate court says, yes, this may have been a problem, but it wasn't preserved, so we're not going to review it or fix it.
So you mentioned that certain things you need to do. What are those things? How do you actually preserve error?
Well, it's different for every error that you see. But for example, in the jury selection issue, if there's a juror that you don't want to sit on the jury for a particular reason, you object to that juror. You articulate your objection. If the judge denies your ability to get rid of that juror, then you need to articulate it again that you have a problem, ask for other strikes, anything you can do, and there are certain things to do, to get that juror stricken. If at the end of the day that juror is still not stricken, when the judge goes to swear in the jury, you have to articulate one last time, I accept this jury subject to my reservation about this particular juror. I have actually handled appeals where the party has said, we accept the jury, and the appellate court has found that to be a waiver of the error. So that is the problem, is you've got to know what you have to do in each particular area of law, whether it's a jury selection, an inconsistent verdict. You have to know what you have to do to preserve the errors related thereto.
Are there exceptions in any particular area for preserving error?
There are a couple. In the criminal law, because you're dealing with life and liberty there are definite exceptions in the criminal law. It's called fundamental error. If an appellate court finds that the system was just so faulty and it fundamentally denied the defendant their rights, they will correct error even if it wasn't preserved. In the civil arena, it really only comes down to maybe inappropriate closing argument that just pervaded the jury. But other than that, if you don't preserve it, you lose the opportunity to raise it on appeal.
All right. A lot of different issues. It's very complex to know jury selection in particular. How do you recommend practitioners learn this to preserve error for different areas?
Of course, it would be wonderful if everybody had an appellate specialist on their team and before they went to trial, they discussed these issues or even during trial. What I would recommend is when you're going to trial, you know what the issues are going to be. I would make sure you do some research on preservation of error in jury selection. When it comes to motions in limine, the rules are very clear what you need to do and what hoops you need to jump through to preserve an issue with respect to motions in limine. If you are concerned that there might be some issues with the verdict, do the research. For example, if the jury rules one way on a verdict and another way and you think it's inconsistent, not inadequate, you want $1 million and you get $500,000, but inconsistent. How can you find fault but award no damages? What do you need to do to preserve error related to that? In that instance, you have to object and poll the jury before they're dismissed or you waive that argument. So you have to be able to identify early on areas where you find there might be issues. There's a witness you don't want testifying. Do a little research about how you preserve the error with respect to a witness that's been allowed to testify. And take that law with you to court. And you know, some judges tend to cut you off. You've heard, I know you disagree with me, let's move on. If you respectfully tell the court, Your Honor, I respect your ruling, I will follow it, but right now I'm just trying to make my record. And here's the law that says I have to do this. Most judges will say, okay, I'll let you make your record and then we're moving on. If you don't explain that to the judge and just sit back and don't do anything, you may have no relief on appeal, and that's dangerous.
Right, and I think that's key, you know, with respect. Yes. You know, got to do that. Any other parting words of advice that you would have?
The main thing is that whatever you do it respectfully with a judge, and that you arm the judge with the information she needs to let you do what you need to do to protect your client's rights. Judges don't want to hear, well, I need to appeal this, so I need to do it. That's not what they want to hear. If you can hand them a rule or a case that says you have to do A, B, and C, they'll let you do it. But you really need to be prepared in advance. These are not issues that you can make on the fly or decisions you can make on the fly when you're in trial. You need to be prepared for these issues. So you need to be preemptive. And do your research ahead of time.
All right, certainly. Well, Jamie, thank you for joining us. As always, you've provided very useful information, and thank you for being supportive of the Young Lawyers Division. And do check back on a regular basis for all sorts of videos that will be able to help you in your practice. Thank you for watching.